Thank you for listening and thank you for watching. Thank you for following. Like the videos, share, and comment. So basically today we are going to look at the declaration of parentage. The declaration of parentage, which is provided under section 110 of the Children's Act. This basically it is made by oath. Again, it is made by oath, unlike other orders, which are made by petition. But this one is made by oath. So basically, and the question that comes, a declaration of parentage is basically a court saying that Kizito Musa, you are the father of the child. That's the declaration of parentage. This comes in a situation whereby maybe they want a person to maintain the child, or maybe, yeah, basically to maintain, but he has denied saying that he's not the father of the child. So you can go to court and ask for a declaration of parentage, whereby court can declare that Matalo, you are the father of this child, so provide for maintenance. Basically, that is the emphasis of declaration of parentage. And someone can go to court to ask for this order before the child attains the age of 18 years, as you shall see. But however, the question there comes that who is a parent? And the law recognizing that a parent is recognized that the child is biological father or his or legal, if the parties are married, any are born in the wife or are presumed the father and the wife and the child and the husband, they give birth of the child in wedlock. So basically that gives the essence or gives the meaning of who is a child. And here it applies that the presumption sometimes it is known as the presumption whereby people are not married. There is a Latin word which is pater estin quam lapit demonstrant. It is a Latin word which means that if a person gives birth to a child when they are not in wedlock, or uh, basically that's the emphasis there. So as we go further, there's also a case before we enter deep. There's a case of SYMC WV official solicitor of 1972. Actually, that case provided for that if at all the surgeon provided that blood test can be used as extremely evidence in most countries for proof of parentage once the test is properly carried out with a competent serologist. Basically, those doctors, they know themselves, and those results that are brought, they can be reliable. So when you go to section 110, who can make this, who can ask for this order of declaration? First of all, you have the mother of the child, the father of the child, the guardian of the child, and the child himself through his next of kin can ask for that declaration of parentage. But here comes before the child attains the age of 18, yeah, or 3 years after the death of the 3 years basically. It can come actually when you read section 111, section 111 of the Children's Act provides that an application of declaration may be made during pregnancy, anytime before the child attains the age of 18, or within 3 years after the death of the alleged father or mother. That's section 111. So basically, as you see there, that comes the essence. And there is a case of Petelonia Birire versus Olivia Nisa Vimana. Actually, that case of 1994 provides that similar, actually, physical appearance, resemblance between the child and the alleged parent is admissible to prove parentage, but such evidence is not conclusive. Basically, they say that it must be corroborated, as you shall see. Corroborated is provided under section 112, clause 3, that such evidence shall be corroborated. So note that in what? In mind, basically. What you have to bear in mind, or what you have to put in mind, is that when uh, when you see that, let me give an example. This essence comes in a way that people are fighting. This one was not the parent. Yeah, the child cannot succeed. He wasn't child. So this has brought many contention whereby many people are going for DNA test just to prove what? Parentage, basically. So we have also other things that are used as evidence of parentage, as we are going to see, that are used by courts of law. First of all is the birth register provided under section 114 clause 1, the birth register. Any person that is on the birth certificate is presumed as the father or the mother of the child. That is prima facie evidence. It is a judicial notice. So that is one of it. We have a signed instrument provided under section 114 clause 2. Signed instrument which is signed by either a mother or a father acknowledging that a person is the father or the mother of the child. And a person named as the father of the child or the mother. Basically, that is a signed instrument. Then we have court inferences. Court inferences, actually, I can give a case of Wine Jones, Mwambu versus Wandoa, Petro, Aaron. Basically, those that want spellings of case, please hit the inbox. I'll drop the spelling. But if you have a reading list, hopefully the cases you can be following. Under this case, court held that a written letter that said that I still expressing that I still remembered that night. Again, the court referred that this letter it was undoubtedly that it tended to prove that this was the father of the child. When the letter is lamenting that I still remember that night, which means that night a lot happened, and this person is the father of the what? Of the child. But however, court held that such evidence should be corroborated following section 112, clause 3 of the Children's Act, the revised one. So we still have another circumstances used as evidence to prove parentage. We have an order of court provided under section 114 clause 3. An order of court can be an order for maintenance. Any person that is ordered to maintain a child, it is prima facie evidence that is the father or the mother of the child. You get. Then we have another one, references in wills provided under section 104 clause 6 of the Children's Act, subsection 6. You may forgive me for using clauses, but they are subsections. So basically, references in will. If someone refers you in a will as his or her child or daughter, it is prima facie evidence that is evidence that the person is the father or the mother of that particular child, basically. Then basically we have blood samples may also be used or to prove what? Parentage. That is investigated under section 102. 112 of subsection 4 of the Children's Act. Blood samples, DNA. Yeah, basically as we discussed it in the case of SYMC, WV, official solicitor, where they say that a test that is made by a competent serologist, the results they can be depended on to prove what? Parentage. So basically that's what the few that I can talk about a declaration of parentage. You get. So other than that, thank you for listening and thank you for watching. Subscribe to the channel, comment and like the videos. Thank you very much. Stay blessed.